Mr. Weinstock.
Judge, I'm here on behalf of Harley Faison, 24 CF 2051. I've had no contact with my client.
State would request that KP come.
Issue a no bond capias.
Your Honor, that's all I have.
See you this afternoon.
Yes, sir.
Mr. Rare.
Good morning, Your Honor.
Good morning, Mr. Rare.
Your Honor, the first, for the record, David Rare, the first case I have on the docket is Miss Eileen Smith, 24 CF 2848, and we have reached an agreement with the state. If I could approach.
Granted.
And there is an FTA capias, Your Honor, in this case.
And the other as well. Oh, wait, no, sorry. You gave me two.
Right.
No wonder Mr. Rare's eyes went cross.
And then with Ms. Leone for the state judge, the agreement with the state is they would not oppose withdrawing the capias, and she would be entering a plea to the third-degree felony FTA, in addition to count one with concurrent terms laid out in the plea agreement.
All right, so to be clear, the capias is withdrawn, but the plea includes the FTA.
Yes, Your Honor, and if I may, we just filed an amended information like 20 minutes ago, adding the FTA count to the original information. I don't know if the system shows it yet.
Madam Clerk,
I'm not seeing one, Your Honor.
I can,
but you've received that, Mr. Rare, and you waive formalities of reading and enter the plea consistent with the amended information.
That is accurate.
All right, so withdraw the capias with the understanding that that withdrawal is based upon the agreement to enter a plea to the amended information, which includes the FTA. And you've had the benefit of the score sheet, which appears to be amended by interlineation. Is that correct?
Correct. I've reviewed
Any
that.
score sheet objections?
None.
All right. Anything else, Ms. Leon?
no, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
Okay, and you put your hand down. Now, you heard what Mr. Rare said, and you signed the written plea form?
I did, Your Honor.
All right. And how old are you?
53.
And how much education do you have?
I had some college.
You able to read and understand the plea form?
Yes, Your Honor.
And did you do that before you signed it?
Yes, Your Honor.
All right. And this plea form tells me that you're pleading no contest to the announced charges, which includes the amendment to the failure to appear.
Yes, Your Honor.
And by doing that, what I understand you to say is that you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, Your Honor.
All right. Do you understand by making this plea, you're waiving your right to that trial by jury, where the state would have to produce that evidence and convince the jury beyond a reasonable doubt of your guilt?
Yes, Your Honor.
And in this case, you will be adjudicated guilty of the charges announced. You will be placed on 60 months of probation with the conditions of the cost of supervision, the court costs which were announced at 518. Is that correct, Madam Clerk? With the exploitation charge?
I think it would just be 515, Your Honor.
515. Okay.
No objection to that.
And no contact with the victim in the case, the 100 hours of community service, and reserve on the restitution, which means that later there may be a hearing where the amount of restitution is determined, or if you can't agree to that amount. An anti-theft course, the evaluation that was discussed, and enroll within 30 days if treatment is recommended.
Yes, Your
Is that what you understood your plea arrangement was?
Yes, sir.
All right. Has Mr. Rare answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. Rare has represented you in this
I am.
case? The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication in this case. Now, if you'll step over this way to have your fingerprints taken and then meet with probation before you leave.
We'll take those right here. And just for the record, counts 2 and 3 are being dismissed by the state.
That's correct, Your Honor.
All right, very good.
And then next on the docket, Your Honor, I think the last one I've got is Ansel Sterling, 24 CF 2653. I think we were set just today for a status prior to jury selection on June 29th. Are there any conflicts the court's aware of?
No, sir, we'll be pulling a jury on 29 June and trying the case.
Thank you, Your Honor.
Perfect. And then also, Judge, on, by the deadline on Monday, June 15th, defense filed a motion in limine. I did speak with Ms. Leone this morning regarding that, and she's advised me that the state is not opposing defense motion in limine,
That's correct, Your Honor. There's no objection.
and so I can provide a proposed order today or tomorrow to the court.
All right. Anything else that we need to take care of in anticipation of the trial on 6/29?
Not that
No,
I
Your
can
Honor.
think of today, Judge.
The only thing I was going to ask, when does the court expect me to send proposed jury instructions?
Well, as soon as possible, that way y'all can work on them.
That's fine.
You know, as soon as you can get them, then the better. That way we don't have to worry about it, the morning of jury selection or anything else. So as soon as you do, and then if there's issues, just simply call the issues out with an email to Ms. Natali, and if I need y'all, we can convene a brief hearing. Yep, we can even do it on Zoom.
Yes, Your Honor, thank you.
That's all, Your Honor. Thank you.
Is that it for today, Mr. Rear?
I believe it is, Judge.
In addition to,
Going back to this. Yep.
Okay. So he gets to bring it back to see if he's credit for his initial infraction sentence and credit from the date of the COP arrest. And up to date, and that includes for the state hospital. So he's not awaiting any.
All right, Mr. Henderson.
Judge, I'll say this is the hallway.
Miss Dudley, I think she said she had to be somewhere else, is that right? Yeah, that's what I thought. All right. Ms. Yeski and Mr. Cochran, you have anything we can dispose of while we're,
I do, Your Honor, I have to, so they're all inmates. Actually, I have two that are not present. Traverse McLemore, case number 25 CF 0379 and 25 CF 1693. When I spoke to his federal defense attorney, Your Honor, he advised the plea forms have been signed, but his sentencing wouldn't be until September. And he did not have a score range yet from the U.S. Attorney's Office on what his score range would be. I do believe that he has been sentenced to federal time on the 25 CF 1695 on that incident. I'm trying to verify that right now. But the 0379, that incident, he's still waiting for the plea.
And my notes indicate that if the state confirms that he was sentenced in the 1695 case, the state intends to null pros the 1695 case.
That's correct. When you were talking, I thought he had been sentenced on 1695.
I believe he has been. It says, if you look online, it says he was sentenced to a prison sentence.
Okay.
I don't have anything to verify it.
Okay. Your Honor, at this time, the state would announce a null pros in 25 CF 1695. We would keep 25 CF 379 on the docket, though. Say until September.
Yeah. The same
All right.
September. Once we have a status date.
Once we have a number that it's likely going to be, then I should be able to address it. We won't need to wait until September. I just don't know when that number might.
Okay, so once again, judge gets a snapshot and you know better. Are you suggesting that this federal sentencing that he's now facing is the facts or circumstances in 379? Or is it a completely different
Yes.
case?
From my understanding, it is the same.
Could we set this out on the next miscellaneous date, not like not during the pre-trial week, but the following miscellaneous date, that would give us time.
Okay. What date would that be?
Yeah. He's here? Yeah. Oh,
Traves?
no, he's, Travis McLemore, he's back? Okay. Let me go back and talk to him, Your Honor, and figure out what's going on with that.
Okay. That's
And the next one, Your Honor,
highly unusual for them to send him to us.
yeah.
And he was here on the last court appearance as well. They've been allowing him to come forward.
Oh, I didn't realize that, okay. Next is Edgar Masoko Vidal, case number 26 CF 0787. This is the gentleman who is in ICE custody, Your Honor. I advised his family to contact me so we could get more information. I have not been contacted on him. His sister appeared last time saying that he
Correct.
likely would be deported.
What does the state wish to do?
Do you want to set it for a status on July 13th? Hopefully I have an update on the deportation status.
Yeah, sure, that would be fine. And then in the meantime, if I get an update from Mr. Cochran, if he's deported, then I'm gonna null pros the case. But if he lets me know, if we figure out the status before that date, I'll make sure that I handle it appropriately so we don't have to deal with it on the pre-trial.
All right, so 7/13 at 9 a.m.
Thank you, Your Honor.
All right,
The rest of my clients are inmates. I'm gonna go talk to Mr. McLemore.
all right. All right, we do have several folks in the gallery. Mr. Henderson, you ready now?
Yes.
Okay, come on down, Mr. Henderson.
Judge Tony Henderson for Richard Stevens. And Judge, we have a plea agreement that deals with both counts of the information. What the agreement calls for is we're in a no contest plea. He'll be sentenced to 5 years of sex offender probation with sex offender designation, adjudication of guilt, fines and court costs, no contact with minors, no internet-capable devices, GPS, and any and all requirements under Florida statutes 948.30. This would be a downward departure based on the plea agreement.
All right. Is that the state's agreement?
It is, Your Honor. Mr. Hutchinson.
Judge,
Yes.
another situation, my client is a resident of California now, and we would be asking that his probation be allowed to transfer. I've explained to him the compact, and it's up to California to accept him, and he would have to remain here until that process was completed.
All right.
Judge, may I approach?
Granted. Do we have a score sheet?
Yes, Your Honor, I'm almost there.
All right. Raise your right hand for me, please, Mr. Stevens. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, you put your hand down. You heard what Mr. Henderson said, and you signed the written plea form?
Correct.
How old are you?
I'm 36.
How much education do you have?
Some college.
Are you able to read and understand the plea form? Did you do that before you signed it? And is what you read what Mr. Henderson just announced to me? Do you understand by this plea arrangement that you're pleading no contest to the announced charges? That tells me that you believe, should you go to trial, that the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes.
Well, you said yes, but you really have a big question mark on your face. You want to talk to your lawyer real quickly?
I mean, we just.
Judge, the way I explained it to him, so it clarifies that there's two reasons that you can enter a plea. One of the reasons is that you're guilty, or that you feel that entering the plea is in your best interest.
Right, so I do feel that entering the plea is in my best interest.
All right, well, so those are magic words the judge likes to hear. Tell me why you believe it's in your best interest to enter this plea instead of allowing Mr. Henderson to do his job in contesting the case in front of the jury.
The max sentence is just too much of a risk. I have a daughter that I can't father from possibly going to prison, and this has just been, like, I've been fighting this case for 4.5 years. I'm just ready to have some closure.
All right, so I'm gonna restate to be sure I understand, and we reach an agreement on why you believe this is in your best interest. After getting advice from Mr. Henderson about how the trial could go, what the potential outcome is, and receiving the state's offer of this 5 years of sex offender probation, you put that in the balance, and you've decided that you'd rather take this plea instead of facing the risk of going to trial and having the potential prison sentence.
Correct.
All right. So based upon that and the advice of your lawyer, you believe this is the best outcome for you under the circumstances presented?
Yes.
All right. Now, has your lawyer answered all those questions that you had about that process and how this plea affects you and the circumstances?
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
All right. Now, one of the things that Mr. Henderson's careful to tell me here is because of where you live and the circumstances of this plea, it used to be the judge could decide, go back. But now the law says that the receiving state, which is the state of California, has to make the decision of whether or not to receive you back under the interstate compact. So that means you must stay here until you get approval from our probation department and a contingent approval from California. And you cannot leave until that happens. And if California says we don't want you, then you're going to have to stay in Florida. Do you understand that?
Yes.
Okay. Does that change your willingness to enter into this plea arrangement?
I mean, I've been a resident of California for a year now, so I would hope that they'll accept me. I guess, is there any information as far as how often they don't? Or?
I wish I could tell you how that algorithm works, but I can't. Sometimes before they hit the button and process the paperwork and it's approved, and other times,
Right.
we don't know. So probation is in a better position. The court really is now out of that decision path. It's between the state of Florida and the state of California. Now, probation is standing up. They may be able to give you some information about that.
The biggest question is if the residence in California meets the conditions of 1,000 foot. That is the biggest one. That is the only reason they would not accept you immediately returning.
All right.
That should, yeah.
That's your question.
All right, any other questions that you have about the plea and how it affects you and the circumstances presented regarding your transfer to California?
No, or if I could ask, how long that process usually is?
It could take a week to 60 days. So it could be a week or a little.
Okay, and in that time, I'm originally from Escambia County. Is it okay for me to be there, or do I need to be in Okaloosa?
It is not okay. You would have to be in Okaloosa County, and you have to be at a residence that meets the 1,000 foot rule. As a temporary residence, the only place that would be acceptable right now is Economy Motel.
Okay.
Okay. So now with that, and that was sort of the next questions I was going to address to you. And I know, knowing Mr. Henderson, I know he's addressed these questions, but we have to put it on the record. Part of this plea is that you're going to be on 5 years of sex offender probation with a sex offender designation. The sex offender designation and the adjudication and the no contact with minors. Now, the defendant has told me that he has a child, and is that no contact with the minors include his own child?
Not his own child.
Okay, so that's not clear in this plea. So we should amend that, right, to say that no minors other than his child?
Yes, with supervision, Judge. Was the negotiating terms, and I apologize.
All right. No unsupervised contact.
Correct.
Is that what you agreed to, Ms. Leone?
Yes, Your Honor.
Okay. And it also talks about internet-capable devices, which, nowadays that we all have one of these.
Right.
That's an internet-capable device. And, I had no clue of all the different things that are internet-capable, right? So a lot of gaming devices you can get online, a lot of now internet, smart TVs, all those different things could be a violation of this probation condition. So you have to be very aware. Generally, I waive this condition for use of devices under supervision at work or school, but that has to be approved in advance by probation. You just can't go to work and not let them know. They have to be aware to be sure to confirm those things. Why am I saying all these things? Because I don't want to set a trap for anybody.
No, thank
And I know Mr. Henderson's gone over this, but we have to put it on the record. In addition, probation's already told you the 1,000-foot restriction. These conditions affect where you can live, where you can work, who you can be around, They may have other consequences for you in other states that I may not know about and that Mr. Henderson may not know about. Our state, for instance, if someone moves here with that designation, we impose upon them in this state all the conditions of our statute, even if they may have not had them in the other state. So if you move to another state with this designation and they have stricter conditions than we have, you're going to have to apply with those conditions. This designation also will travel with you for the rest of your life.
Oh, that's something I did not.
Yes. Do you want a minute to talk to Mr. Henderson about that? Had your questions answered?
Yeah.
Okay, all right. All right, and with that, are there any other questions about this plea, how it affects you, and the circumstances presented with your transfer back to California that have not been answered that would affect your willingness to enter into this plea?
No.
Okay. All right, the court will find the plea to be freely and voluntarily entered into, will accept the plea, and you got that score sheet. Mr. Henderson, any objections to it?
No objection.
Granted. All right, thank you, Mr. Henderson. All right, so sir, if you'd step over this way and have your prints taken, and then you'll meet with probation before you leave, and they'll give you your instructions. Anything else for you today, Mr. Henderson?
No, that's all I have, Judge.
Thank you now. Good day. Have a safe journey home.
Thank you.
Your Honor,
Yes, sir.
I have Mr. Kyle Madonia, 26 CF 0167. Said PTI. I have the signed agreement here, if I could give it to the clerk.
Yes, sir. So that was Madonia, you say? And that was here just for the PTI status is what my notes indicate, correct?
Yes, Your Honor.
State, you agree?
That's correct, Your Honor.
All right. Good morning, Mr. Patel.
Good morning, Judge.
You need a minute, or are you ready?
I'm ready.
All right, sir.
Good morning, Judge. Jay Patel on behalf of Fang Wang, 26 CF 136. We're before the court on a motion to return property that was reset from 6/18. I don't know what the state's position is.
I talked to Fort Walton Beach PD, and they don't have an objection to the return.
All right, so the state's conceding the motion?
Yes, sir. I'll follow up with an order, Judge.
All right. Thank you very much.
I have nothing further, may be excused.
Yes, sir. Thank you. Good day.
It's one guy. Your Honor, my clients are all in custody. I can call them if you'd like,
All
or...
right, so we have a lot of folks in the gallery. Anybody here for your own case? Or are you here for folks who are, all right, so let's start with you. Come on down. What's your name, please? Last name is? Do you have a case number by any chance?
No, sir, I'm sorry.
All right.
Well, actually, I might. It's from my soon-to-be ex-husband's arrest, but it was in Holmes County.
But it's a case for you or for your husband?
Well, I'm filing an injunction against him, so I guess myself.
Oh, you're probably in the wrong place. I think you need to be in Judge Brown's courtroom.
Is this not 1A?
This is 1A, but this is a criminal proceeding, so you may be in the wrong spot.
Oh,
You need to be upstairs in 2B. Would you please call Judge Brown's bailiff and tell him, get her name and specifics, be sure they know that she's been here all morning so that there's no issue with her appearance, okay? All right, someone else with a case here of their own? Yes, ma'am. Your name is?
It's Holly Martin, my lawyer, Brad Stewart, he's supposed to be here at 10:30.
Yes, ma'am. He indicated that he'd already sent me a notice, and through my JA said he is in Walton County first, and I'll be here after a little bit.
Okay.
All right, thank you now. All right. All right, so let's cue our, you ready with inmates, or do we need a break to get ready?
We're ready for inmates.
All right.
Did you want to tell the judge that information? You want to tell the judge that information? Sure. Had a case this morning? No, she didn't want to pass you. I think it's part of his here. Her name is Harley Faison. I believe so.
Well, tell her to call our lawyer,
Yes, sir.
because we issued a capias for her.
Yes, sir.
Did we see Mr. Weinstock leave the courthouse already?
Single point, Mr. Weinstock leave the courthouse.
He is gonna be back this afternoon if.
He's gone.
All right.
Inmate, Your Honor.
All right.
Evan Lowe?
I just have one moment, Your Honor. Your Honor, my client has just given me a counter offer to give to the state if we could hold her for a few minutes.
All right, and what's this case number?
Oh, I'm sorry,
Just so
this
we
is
make a
Miss-
good record.
Ursula Evans Lowe, 24 CF 2698.
2698,
What's the
okay.
counter?
Your Honor, we've reached an agreement. I'm going to need a few minutes to take care of that. If we could hold her for a little bit, I'll get that taken care of.
Yes, and make her available for taking the plea.
This way. Next to me, Lucas, Lucas.
Your Honor, we've reached an agreement this morning. I just need a moment. Your Honor, we have reached an agreement this morning on Ms. Luandra Lucas, 25 CF 1905. She has a misdemeanor case that she'll also be resolving with this. Sorry, Madam Clerk, I forgot to give you that number. It's 26 CT 0962.
And just to be clear, on the CT case, I'm taking this plea as a convenience to the county judge. Is that what we're doing?
Yes, Your Honor, it's a credit time served offer.
Okay.
We're doing it because her next court date is not until July 13th, and this will get her out of jail today. In exchange for an admission of the violation on the 25-1905, the state has agreed to maintain their withhold, modify to add 24 hours community service. All other conditions remain, court costs and cost of defense. As for the 26 CT 0962, the driving while license suspended will be an adjudication, credit time served, and court costs. I have the signed plea forms and this score sheet, if I may approach.
Granted. And that's the state agreement?
It is, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay, and you can put your hand down. You heard what Mr. Cochran said and you signed the written plea form? How old are you? How much school do you have? All right, you able to read and understand the plea form? And did you do that before you signed it? And is what you read in the plea form what was announced? All right, so you understand that you're admitting the violation in this case, waiving your right to a hearing where the state would have to prove your violation, right? And your withhold adjudication will remain, and you'll have the additional 24 hours of community service, and you'll have $100 cost of prosecution, $150 cost of state-provided legal assistance. And then in your 24 CT case, you are pleading no contest, and you'll be adjudicated guilty and get credit for time served. What will the court cost on that be, Madam Clerk?
I believe it'd be 300, Your Honor, but I'm confirming with my supervisor.
Okay. And are we going to pay those court costs under the terms of her probation?
Yes, Your Honor.
Okay, so the court cost in the 26 CT 962 would be paid under the terms of the 25-1905 felony case.
And Your Honor, I would ask that the cost supervision be waived until she is employed.
COS is waived until employment is achieved and for 60 days thereafter.
Thank you, Your Honor.
Please freely and voluntarily entered into and accepted. Thank you.
Where's next? We have Travis and Matt.
I have one moment, Your Honor.
Yes.
Your Honor, we have Mr. Travis McLemore in case number 25 CF 0379. Your Honor, this is a violation of probation. In exchange for an admission, the state has agreed to term and revoke. It'll be 5 years Department of Corrections to run concurrent with his Bureau of Prisons federal sentence, court cost and cost of defense. I have the signed form and the score sheet if I may approach.
Granted. State?
That's the agreed upon sentence, Your Honor.
So this is the 379, and this is a VOP, correct?
Yes,
That's
Your
correct, Your Honor.
And this is credit for all time served?
Yes, Your Honor.
Yes, Your Honor.
What about costs? What do we want to do with those?
Your Honor, I'd say put him to a lien. He's gonna be in DOC for 16 years, so.
Okay.
Sir.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Mr. Cochran said, and you signed the written plea form.
Yes, sir.
You understand by this plea that you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated my probation the way the affidavit report by my officer says it did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And in this case, you'll be adjudicated guilty, if not previously. Your probation will be revoked and terminated. You'll be sentenced to 5 years in the Department of Corrections, with your sentence to run concurrently with your present Bureau of Prisons sentence and to be served in the Bureau of Prisons. You'll get credit for all time served. You'll have an additional $100 cost of prosecution, $150 state provided legal assistance, and all your fees and costs will be sent to a lien. Is that what you understood?
Yes, sir.
Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how he's represented you.
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you now.
Thank you, Your Honor.
No, do we have a case number for the federal case so Madam Clerk can be certain that on the plea and sentencing agreement it's clear?
I do not, I'll email the federal attorney, see if I can get one, and I'll get it to you.
All right, please do. That way there'll be no confusion when that comes up. Because we will get a message from DOC about that.
This is Nigel Fryer. This is Nigel Fryer, for two case numbers, 21 CF 192 and 20 CF 2443. These are violations of probation. We're here for an arraignment. We'll enter a denial and ask for a hearing date to be set without subpoenas.
All right.
There are some moving pieces. This was originally a youthful offender sentence. He's bonded out of Georgia, where he's been for the last 18 months, which are the reasons for the violation are the new charges in Georgia, which are still pending. So I need to negotiate with Mr. Snell. And I need to communicate with the public defenders handling the cases in Georgia to see the status and where they're at out there. So I would ask for 7/23.
All right, 7/23, no subs?
Correct.
Okay. All right, very good. See you then. Thank you, Nick.
Yes, sir.
Next, we have Raul Miller with Mr. Rialli.
Mr. Gomez just stepped out briefly.
All right.
Here he comes. Good morning, Your Honor. Joseph Riasti for Raul Alfredo Mila Jr. in 2023 CF 1501, 2023 CF 2492, 2023 CF 2493, 2023 CF 2513. This case was set for two purposes. One, the state had provided a 25-year offer that was a global offer to resolve all 4 cases with 25 years in DOC with no probation to follow, with the strict understanding that it expires today. I explained all of that to my client. He's aware of the offer and the implications of if he doesn't choose to accept it, and is elected to not accept that offer or reject that offer. The case was also set to allow Mr. Mila to enter an open plea to all 4 cases, and he's still considering that. However, he's expressed to me a desire that he wants to additional time to talk to his family. And he has asked the court to understand that it's a difficult decision that he's trying to make, and he's trying to get all the input that he can from his family and his friends in order to make that decision. This is not meant, his delay in entering a plea, if he ultimately does on pretrial, is not meant to yank anybody's chain or for obfuscation purposes. It's just the fact that it's a huge decision, and he wants the time to reflect on that. So with that in mind, I ask that the court leave these cases set for pretrial on the 13th, I believe they're set, with the understanding that this case, there's no continuances to be granted, and this case will move to trial after that. Mr. Mila is also aware of that. He's expressed to me his family's desire potentially to bring in a late attorney hire, and I explained to him that if he wants to go to trial, whether it be with me or with any other attorney, that decision needs to be made as soon as possible, so that we can begin to move towards a trial posture. But up until now, he's strongly considering entering an open plea, with the understanding, it affords him the opportunity to present a mitigation report and a sentencing memorandum, and that's at least right now what he's strongly considering. You can inquire if you need to.
Mr. Riosti had notified me of what his client was feeling today. The state does revoke its 25-year offer, and at this time, we'd be ready for trial come the 7/13 or July 13th pre-trial, with the understanding that obviously he can enter an open plea to the court at any time up until jury review.
And I've let Mr. Mila know that if we're moving to trial, if we're having any motions, I need to have them filed immediately. So,
correct.
And that's why I've told him I'm planning on meeting with him next week with the understanding that I'll be beginning to move towards trial preparation.
Which case are we going to try on 7/13?
4623 CF 1501, Your Honor.
All right. And my last notes indicated we believed it would take 2 days plus jury selection and 50 jurors.
That's correct, Your Honor.
And I would concur with that estimate. If the case goes to trial, if he pleads out, Your Honor, on pretrial, we would be asking for a sentencing date to be deferred into possibly late August or early September, if the court would entertain that. And that would allow me to have Mr. Mila evaluated by an expert and present a mitigation report, which is our intention.
So we'll cross that bridge when we get there. I'm going to give you the time you need to be sure you can do an adequate job for Mr. Mila.
And Mr. Gomez and I are anticipating potentially a 2-hour sentencing on this if it eventually goes to that. possibly 90 minutes, but most likely 2 hours.
All right. All right, we'll remain set for pretrial on 7/13.
That's all I have before Your Honor.
And Mr. Riosti, Ms. Natale just notified me, I'm not sure this is not about your case, that you were appointed, actually, I think, yesterday afternoon on a case that's on our 1:30 docket.
Is there a way that we could handle that today? I didn't know it was on the 1:30 docket.
It's a arraignment with, if you want to jot it down, I'll give you the information, you can chat with the state. It's,
I've reviewed it, but there's no way to handle the arraignment right now.
I don't believe they're here.
Is it in custody?
Yeah, Rivera Soto?
They're here. They're actually over on the side too.
Well, it depends on the state's ready or not. You got the information, Madam Clerk?
I hate to impose upon the court, but
Does he need an interpreter?
I'm not aware. It's not my understanding that he needs an interpreter.
I don't know.
Jacob, can you find out?
Yes.
2060?
Because if he needs an interpreter, then we can't do it right now, Mr. Riosti. Luis Rivera Soto, 26/7/22. It's arraignment this afternoon.
Is this the case that's a battery on a jail detainee?
I don't know. I would have to look at the doc. He doesn't need an interpreter, so bring him out.
Does Madam Clerk know the status of his bond right now?
But he's represented by private attorney, so I'm not sure that he qualifies.
Yes, it's battery on a person detained.
But he is a private attorney. No, it's not the PD. He's a private attorney, so is he entitled to public defender?
Well, actually,
Have you heard?
Joseph Riosti for Mr. Rivera Soto, who's present before the court in the new charge, which I believe is battery on a jail detainee. He has a pending case in which his family, not him personally, he's incarcerated, as you see, Your Honor, and as such, he's per se, in my opinion, he's per se indigent. He has no means as an incarcerated individual to earn any money or to pay any attorneys. And it's my understanding that Mr. Machevich is aware of the new charge and has denied or has not elected to accept it, which renders him unable to get another attorney with regard to this. So I believe that my appointment is proper and that I should proceed, I should be allowed to proceed as he's indigent and incarcerated up with regard to.
Yes, sir. Well, your appointment comes as a result of the withdrawal of the office of the Regional Conflict Counsel.
I understand that, Your Honor, but the state may have an objection to me being allowed to represent him with the fact that he has a private attorney, so I wanted to address that.
Okay.
The status of my representation before we move forward.
All right.
Does the court agree that he's indigent and I should be allowed to proceed?
He's been found indigent.
So, with that in mind, I will enter a plea of not guilty on his behalf and ask for 15 days to file appropriate pretrial motions if there's any.
All right. Well, not guilty. It actually looks like Mr. Klein's, before he withdrew, filed a written plea of not guilty and a waiver of arraignment. And well, I think it's set for 7:13, Madam Clerk, is that right?
Yes, Your Honor.
All right,
I'll be here at 7:13 also, so.
all right, very good. See you then.
Your Honor, thank you for allowing that.
Yes, sir, good day.
This is Miss Tracy Rosado. She is here in 23 CF 457. I did meet with her yesterday at the Okaloosa County Jail, and we have been going through the process of filling out all the additional paperwork that APD wants to get to a determination on eligibility and placement. That is still the direction we're going, but we're still digging through the paperwork, unfortunately, even after all this time. So I'm going to be requesting an additional continuance. I've been told that we've submitted everything that we need at this point. So we should have an answer forthcoming on eligibility and placement. And that should take care of our violation of probation.
So,
No objection, Your Honor.
status for when, do you think?
I would ask for an August date with the anticipation that if I get that tomorrow, I'm going to be ringing the court to try to get it in, get it done. But just to make sure that we have the time that we need. Because once we get past the eligibility hurdle, which I don't know why we're having to do that again, but we are, then we're at the placement for Ms. Rosado. And I don't anticipate that that's going to take too long once we cross the eligibility hurdle.
All right.
But those moving pieces still exist.
So, Madam Clerk, a second date in August, with the understanding that it'll be advanced if it was resolved.
Thank you, Judge.
Can I be August 20th, Your Honor?
8/20.
Thank you. Judge, this is Mr. Matthew Teams. We had moved his case from last week to this week for his bond hearing in 4 case numbers. Those case numbers are 25 CF 1884, 26 CF 96, 26 CF 95, and 26 CF 94. Procedurally, if we look at the 4 cases I just announced, he was on bond in the 25 CF 1884 case. When he came through on the 3 26 CF cases. Originally, it was set for a pretrial detention hearing. There was issues related to, or a motion related to competence. There was an evaluation and a report. So it was never circled back around to either have a hearing or set a bond. The state never filed a pretrial detention motion in the 26 CF cases. So we're asking the court to consider setting a bond in 26 CF 96, 26 CF 95, and 26 CF 94. And we're asking the court to consider reinstating the bond in 25 CF 1884, which was revoked because of the new charges. I would ask to take some brief testimony from Mr. Teams.
Raise your right hand. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Sir, I've listed 1319 Jeff Green Drive in Crestview, Florida as a good address. Is that a good address for you?
Yes, sir.
Who lives at that address?
My mother,
Anybody else?
her husband.
And you're welcome at that address?
Yes, sir.
What type of prior employment experience do you have?
I own a tile company.
If you were going back to work today, what type of work would you be doing?
Most likely tile.
So you'd be going back to construction and tile work? Do you have any additional family that lives in the area?
Not in Crestview.
It's just primarily your mom that lives there?
Yes, sir.
Would she be supportive and be able to help you come to court or any appointments that you need to go to?
Absolutely.
Okay. I have no further questions for Mr. Teams.
The state has no questions for Mr. Teams at this time.
All right.
And I have no additional witnesses. I'll pass to the state.
He said he had additional witnesses.
I do
No, he
not.
said he has no additional witnesses.
Well, the state's position on the establishing bonds, we have some recommended amounts that we've asked the court to set on 94, 95, and 96. And there, we would object to any kind of, to any bond being reimposed on 25, 1884 at this time.
So you've recommended bonds on the other?
I have bonds that I would recommend, yes, sir.
Okay. All right, so what are the bonds that you're, so my memory is, we have there's 3 different charges, and it seems to be a series of events. I don't know it would qualify as a single criminal episode based upon how it happened, but that's probably an argument for a different day between the two of you. But right now he has 3 cases: unarmed carjacking, burglary of an occupied residence, and
Fleeing, attempting to elude.
fleeing, attempting to elude. All right, so those are the 3 charges. So
And there's a grand theft of an automobile.
that's part of the carjacking
Correct.
case, right? Okay, so we've got, so tell me what the recommended bonds are from the state.
So in in case 26 CF 94, count 1 grand theft auto, the state would recommend $10,000 cash or professional. Count 2, fail to obey or flee to elude, would be $5,000 cash or professional. In 2026 CF 95, burglary of an occupied dwelling, the state would request $50,000 cash or professional. And on the 26 CF 96, the carjacking case, the state would ask the court to impose a $350,000 cash or professional bond.
Mr. McKinney.
Judge, those amounts would be tantamount to no bond for Mr. Teens. I believe his mother would be the person primarily making the bond amounts. I believe that she helped post the original bond. In 25 CF 1884, there was a bond that was posted, I believe was approximately $8,500, $8,500. I could be wrong on that amount, I apologize. 3, 4. In essence, I believe that those amounts my client would not be able to post. That's before we get to the argument of asking the court to consider reinstating the bond in 25 CF. So I would ask for $5,000 cash or professional in each of the cases counts.
All right. Any further argument on the amounts?
The amounts, I believe, are appropriate, and I can go into the state's reasoning behind that, based on the facts and also the facts surrounding the case that Mr. Team is on probation for. You've got a situation where or out on bond, I'm sorry. That they were pending. I misspoke, that's correct. There's a situation where in both incidents where Mr. Teams not only put himself in very great danger, but he put the public in great danger. The complete disregard for his own safety and the safety of others is very concerning to the state. You have a situation where, in the 1884 case, where Mr. Teams is videotaping small children at a school and runs from the police, and after that incident, then you have a situation where he randomly steals a car from a parking lot and then goes on a high-speed chase to get away from the police, and then goes into someone's home that doesn't know he could get himself killed, and someone in the home could get hurt. Then tries to get into a car with a mother of 2 small children, which goes back to not only Mr. Team's prior criminal history, but also the event there at the school. And this all happened while he was out on bond, and so the state believes that the bond amounts recommended in the new charges is appropriate, and that the bond should remain revoked in 1884.
Any further arguments?
No further argument.
The occupant of the house stated he was in his room when he heard his dog barking. He got up to see what the issue was and encountered the defendant in the living room. He stated he observed the person and did not know who that was, and the person did not have permission to be in the room, to be in his house. That's the burglary. The defendant approached a running vehicle occupied by a woman and her 2 small children after the children were placed in the vehicle. The defendant observed enter the residence and attempted to forcibly enter the passenger side of the vehicle by pulling the door handle. The victim, in fear for her safety and the safety of her children, to prevent the car from being stolen, put the vehicle in reverse and fled the scene as she was calling 911. As the victim was leaving the scene, she observed the defendant attempt to enter another vehicle on the property before she then called the occupant of the residence.
Mr. Team saw the father of those 2 children go back inside the house before he attempted to get in the car. And he acknowledged to police that he saw the two small children
And
in the
so-
backseat.
So the court finds that given the, and the facts of, and the reason I'm reciting all these things, y'all know I often don't go through this, but if I'm gonna set a bond, then I'm supposed to look at, and each one of these charges qualifies for pretrial detention. And I can't speculate on why the state didn't move forward, except to possibly because they, based upon 907041, the defendant's, no, yeah, 907041, the defendant's pretrial release was revoked for his probable cause to believe he committed a new law offense, and therefore the state may have felt like, it's a belt and suspenders, his bond is revoked. The underlying charge on which he was out on bond would also have, one of them would qualify for pretrial detention. So we have an attempted carjacking involving a mother and her two young children, a burglary of an occupied dwelling, which, interestingly enough is, one of the original common law crimes, right? That's the common law crime. Then we have the theft of the motor vehicle, which, if we read the addendum probable cause carefully, the defendant appears to have laid in wait for the victim of that to exit the vehicle before he jumped in and drove away, literally, as he was going in the door. So it could have been another carjacking right there, circumstances. The court finds that actually the bond, particularly on the question that the state's recommended on the burglary is modest. So the grand theft of $10,000 is appropriate. Flee, attempt to elude, based upon the fact that he was out on bond on a flee and attempt to elude before. The court finds that appropriate bond on that is $25,000. On the burglary of an occupied dwelling, the court finds that a $250,000 bond is appropriate. On the attempted carjacking involving a victim and two young children, $350,000 is appropriate. And the court declines to reinstate his bond based upon the finding of probable cause that he has committed new law offenses while out on bond on cases which would qualify for pretrial detention as well.
Yes, sir. The next court date, I believe, is 7/13 for pretrial.
I believe, is that right? Yeah, it looks like we're set for 7/13. You were proceeding before the new charges, I believe.
We have depositions scheduled on
correct.
all cases tomorrow.
Correct.
So we should be in a better position to know where we stand on 7/13.
Right. All right, very good.
Next is Randy Williams. Randy Williams.
Morning, sir.
Judge, we have reached an agreement in the violations of probation. The agreement is going to call for Mr. Williams' probation to be reinstated to complete the original conditions. And there was originally a term for inpatient treatment with Phoenix House. He was medically discharged from that program, and we are modifying that term to JADA, bars to bed. We're going to ask the court to waive the cost of supervision while he is completing the JADA program, and there are the additional costs that would be imposed. May I approach with the agreement on the violation of probation?
Yes.
One at a time. Typically, yes. And Mr. Williams' question primarily for the court is he's seeking to advance his education, so he's asking if the court would consider waiving the cost of supervision after the program if he is in school. Is that the question? May I
Yes,
approach?
if he is advancing himself by education or training that will lead to bettering himself, I'll waive the cost of supervision. All he needs to do is get enrolled, and I'll do that. All right, raise your right hand. Swear affirm, testify truthfully in this matter under penalties of perjury.
Yes, Your Honor.
All right. You heard what Mr. McKinney said. You signed the written plea form.
Yes, sir.
You understand that you're admitting the violation.
I do.
And you'll be reinstated to your probation original terms, modified to JADA. You stay in jail until they come and get you.
Yes, sir.
Then you'll have the additional fees and costs were announced. And the cost of supervision will be waived on the terms and conditions that were provided.
Thank you, Judge.
All right.
Okay.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
And they'll come get you. I can't swear. Thank you, Judge.
This is Brandon Zimbus.
Judge, this is Mr. Brandon Zemsch before the court in 26 CF 586. Judge, he is here in case number 26 CF 586. That's what we're going to work on. Judge, there is a report that was filed in this case. Has the court had the benefit of that report?
Yes.
And that opinion basically says that Mr. Zemsch is incompetent to proceed. We'll stipulate to the entry of the report. And it states that there is competency restoration, that he doesn't qualify for Florida State Hospital is the recommendation in the opinion. I did reach out to Ms. Varela, who is the forensic health specialist. May I approach with what I received from her? I have shown a
Yes.
copy to the state.
Yes. Does the state stipulate to the report?
To Dr. Zeman's report?
Yes.
Yes, sir, I do.
I believe it would be appropriate to set a status court date for the forensic mental health specialist to work on the competency restoration plan.
Do you wish to file that, or they're holding that? Okay.
I wanted the court to be aware so that she could let the court know that she would be the contact related to a competency restoration plan. And so I would like to set a status date so that we can see how that develops.
Very good. And what, we want to set it on 7/13?
That would be 7/16.
7/16 for miscellaneous day.
Correct. I'd rather set this on a miscellaneous date.
All right, 7/16, 9 a.m. All right, very good.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
This is Raul Perez before the court in a slew of cases, 25 CF 644, 25 CF 642, 643, 24 CF 903, 24 CF 2182, 25 CF 75, 25 CF 74, 25 CF 71, 26 CF 1104. Your Honor, Mr. Perez has been approved for drug court, and me as well as the state are working on the terms for that. The plan is eventually, we're hopeful that Mr. Perez will be able to come into drug court.
We're hoping that'll occur hopefully next week. He has a new law case that we're having to kind of massage out to be able to get him into drug court. I think it would be prudent to, I think his arraignment technically on that new law case is 7/16, if I'm not mistaken. So I think if we just leave it set for that date, the hope is that it should be off the docket by then.
All right. So we should set a date for review here and just put it on 7/16 for status?
Correct, Your Honor.
All right.
That'd be perfect.
So ordered.
Thank you.
Now, Ms. Dudley, Mr. Stewart, are y'all ready?
Yes, Your Honor.
All right. Ms. Dudley, come on.
I just need 1 second, Your Honor. Your Honor, we are here on Johnny Reynolds in 26 CF 907. We are set for a motion to reduce bond. Your Honor, we have an agreement with the state that the bond will be $25,000 on the possession of firearm by convicted felon, $25,000 on the possession with intent to sell, and $100,000 on the trafficking charge, for a total of $150,000. His
Okay.
bond is currently over $1 million, I believe.
All right, and you'll provide an order, and that's the
Yes,
state's
sir,
agreement?
I'll get it to you within an hour.
All right, very good, thank you. All right, very good, thank you.
Thank you, Your Honor. That's all I have. We back this afternoon?
Good morning, Your Honor.
Good morning, Mr. Stewart.
May it please the court, Your Honor, Brad Stewart, on
And
behalf
once
of
again,
Holly
to be-
Martin.
To be clear, I want to be sure your client's been here, and thank you for letting Miss Natali know. I had notes on my docket. I appreciate you letting me know.
Yes, Your Honor. Your Honor, may it please the court, Brad Stewart, on behalf of Holly Martin, for the record, 25 CF 1019 and 1029. I'm present before the court now. Ms. Martin is prepared to tender a plea of no contest. Judge, I do have a fully executed plea sentencing agreement along with the corresponding score sheet. May I approach?
Granted.
Your Honor, the agreement calls for a withhold of adjudication on case 1019 on counts 1 and 2. There will be a concurrent 2-year session of probation, 615 in court, cost 24 hours community service work, substance abuse evaluation with treatment is recommended, eligible to automatically terminate at 1 year if she completes requirements, and no violations. Count 3, DWLSR, is withhold and concurrent court costs. Judge, 25 CF 1029 shall be dismissed in exchange for said plea.
All right. State.
State's agreement, Your Honor.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right, and you put your hand down. You heard what Mr. Stewart said and you signed the written plea form.
Yes, sir.
How old are you?
I'm 34.
How much school do you have?
Not a lot.
Okay. Are you able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes, I did.
And what Mr. Stewart just told me, what you read in the plea form?
Yes.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me as to those charges, you believe the state could prove your guilt to a jury and you're not going to contest that.
Yes, sir.
And do you understand by doing this, you're waiving your right to the trial by jury?
Yes, sir.
And in this case, adjudication will be withheld. You're going to be on 2 years of probation with the fees and costs and the conditions, including the evaluations and treatment, the community service hours, and you'll be eligible for termination at 1 year if you complete and there are no violations. All right. And in return for the plea, the state agrees to dismiss the 1029 case. Is that what you understood?
Yes, sir.
And Mr. Stewart, answer all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. And if you'll check in probation before you leave. Anything else for you, Mr. Stewart?
No, Your Honor, that's all I have. Maybe excuse me.
Yes, sir. Good day.
Thank you, Your Honor.
Mr. Weinstock, welcome back. Did you have a chance to meet Ms. Faison?
Yes, I did, Your Honor.
All right.
May I approach?
Granted.
Your Honor, Ms. Faison, Harley Faison is here on 24 CF 2051. First thing I ask is the court will retract the capias.
Any objections?
No, sir.
Withdraw the capias.
She's accused of not completing her PTI
Correct.
program. And I do have with me doctor's records to show that she was in the hospital at the time that some of the issues took place, and also a toxicology report that shows that she's been negative. If I may take a second.
Sure.
Mr. Weinstock just showed me some documents from
Sacred Heart.
Sacred Heart, and I believe he's going to email me those. And so we could set this for status on that 7/16 date, and it'd probably be resolved before then. I just need to go over that with the original charges.
All right, so set for status on 7/16?
That would be my suggestion. Yes, sir.
All right, 7/16, 9 o'clock.
Well, Your Honor, I'm going to be here on the 13th also. Any chance we can move it to the 13th?
Be fine with
That's
that.
a busy day, but yes.
Like 7:13 then, Your
All
Honor.
right, we'll do it 13th.
Thank you.
Thank you.
Yes, ma'am. Stay in touch with Mr. Weinstock. Be on time next time, okay? Because we issued a warrant for you.
I know, I just don't have a car right now, and with everything else going on, I do apologize.
Yes,
Thank you.
and I start late on purpose to be sure that nobody gets caught up at the front door or anything like that. So just, if you're late, let your lawyer know. He'll tell me, right? So as you know, I keep notes just like the lawyers tell me if they're going to be late. So I keep notes. If you communicate effectively about what your situation is and stay in touch with your lawyer, you won't get in trouble. It's when you don't let folks know that's when you're going to get in trouble, okay?
Yes, sir.
At least with me. I can't speak for anybody else, but at least here in this division, that's the way it works.
Thank you.
Communication is key.
Thank you.
Okay? All right,
I
good
do
day.
appreciate it. Thank you.
Your Honor, may I be excused?
Yes, sir. Thank you, Mr. Weinstock. I appreciate you coming back promptly. All right, I'm going to take just a comfort break at this point in time, just 5 minutes, okay? All right. 5 minutes. about how you violated your probation. And by doing that, you understand you're waiving your right to a hearing where the state would have to prove you violated. In this case, you'll be adjudicated guilty. If you weren't previously, you'll be sentenced to 9 months in the county jail, and your probation will be revoked and terminated, additional cost of prosecution and cost of defense to be assessed, and monetary requirements for how much time?
If I may have. Ms. Romero has indicated that 2 years to pay would be sufficient, if the court would allow.
Yes, ma'am, that'd be good. Now, one of the principal issues about this plea agreement is you're doing something that doesn't ordinarily happen. You're waiving your right to credit for time served. Do you understand that?
Yes, sir.
And that's part of the principal deal with the state, is that your credit goes only for the arrest in this violation. All your prior credit is being waived. You understand that?
Yes, sir.
Okay. Ms. Yeske answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how she's represented you.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication.
This way, sir. Take me, Jeremy Ross. Mr. Ross.
Your Honor, may I have a brief moment for... And Your Honor, just for the record, this is in case 24 CF 1756. That's the violation of probation case. And we also have 26 CF 1047. That case is set for an arraignment on the 16th. However, we are in receipt of the information in that case, waive formal reading, and we can resolve all cases together today. These are the following terms. In 24 CF 1756 would be admit the violation, adjudication of guilt, revoke and terminate probation, serve 6 months in the Okaloosa County Jail with credit for all time served, $100 VOP fee, $150 cost of defense. And in 26 CF 1047, that would be an adjudication of guilt, 6 months in the Okaloosa County Jail with credit for all time served, court costs, and that will run concurrent with the prior case 24 CF 1756. The agreement has been signed by all the parties. May I approach?
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
And you put your hand down. You heard what Ms. Yesky said and you signed the written plea form?
Yes, sir.
All right. Now, you've got two things going on today. You got your VOP and your new charges. We're taking care of them together, but they're two separate things. You understand that?
Yes, sir.
All right. How old are you?
I'm 30.
How much school do you have?
I have the electrician and plumbing degree.
All right, very good. Can you read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in this plea form, what Ms. Yesky just announced to me.
Yes, sir.
All right, as to your VOP, you understand that you're admitting the violation.
Yes, sir.
And that tells me, yes, Judge, I violated the way my officer says it did.
Yes, sir.
And do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that?
Yes, sir.
As to your new charges, do you understand that you're pleading no contest?
Yes, but Honor, how does that work? When I'm serving my time in the jail, how does that all work? Because you said that it's two different cases. Is it run all concurrent, 6 months, or is
Yes,
it run?
the sentences will run concurrent. You may have different credit for time served, so they may not end at the same time, but they'll run together.
Okay, so when that whole 6 months is done, then I can leave, because I have a child I have to take care of. He's like he's 6 months here, 6 months old, and I have a BCS case and all that other stuff going on.
Yes, sir. Once again, I don't know exactly how much credit you have, but you just assume since you have a 24 case, you served some time before.
Yeah.
So you get credit for the time before, so your 6 months on that would expire before your 6 months on your new charge. So your
Okay.
credit for time served is different.
So I'm not
But-
going to prison, right?
No, sir.
Okay, thank you.
I mean, we'll get there and talk about that.
Okay.
But as to your new charge, you understand that you're pleading no contest,
Yes, sir.
which tells me you believe the state could prove your guilt and you're not contesting that.
Yes, sir.
And by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
All right, now we'll talk about the sentence. You're getting, on your violation, it's a revoke and terminate your probation,
Yes, sir.
6 months in the county jail, credit for time served.
Yes, sir.
On your new charge, it's 6 months county jail credit for time served, and they will run concurrent, but they just won't terminate at the same time.
Okay.
Okay? Ms. Yesky answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how you've been represented?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you. If you'd step over this way.
Your Honor, this is Cody Stam before the court in 24 CF 2408 as well as 24 CF 2251. We have an agreement reached in this case, and if the court will allow, Mr. Stam also has a misdemeanor case with a sentence of jail time that would coincide with this VOP, and we could resolve them all today. I've looked into the offer in that misdemeanor case as well as the state attorney has as well, and we would request to resolve all today with an agreement.
What's that case number?
That is 26 MM 1119.
1199?
I have 1119.
Oh, 3179. Okay, you got that, Madam Clerk?
Yes, Your Honor.
And we're doing this as a convenience to the county judge?
Yes, Your Honor.
Okay.
The terms of this agreement will be in 24 CF 2408 as well as 24 CF 2251. Those are the two felony violations of probation. It will be admit the violation, adjudication of guilt, reinstate the standard probation, extend this probation 12 months from the original end date, no drugs or alcohol without prescription, serve 90 days in the Okaloosa County Jail with credit for all time served, complete a substance abuse eval and any recommended treatment, abide by any injunctions, $100 VOP fee, $150 cost of defense. And then in 26 MM 1119, it would be an adjudication of guilt, 90 days in the Okaloosa County Jail with credit for time served, $270 in court costs. And that misdemeanor case is the purpose for the violation here. And if I may just have a moment to get signatures. May I approach with the signed agreement?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
You put your hand down. You heard what Ms. Yeske said and signed the written plea form.
Yes, Your Honor.
Now, we're taking a plea as to your misdemeanor and also to your violation of probations in these cases. Do you understand that?
Yes, Your Honor.
All right. As first, to the violation of probation, you understand that you're admitting the violation.
Yes, Your Honor.
And that says to me that you agree with what your officer says about how you violated your probation.
Yes, Your Honor.
And by doing this, you understand you're waiving your right to a hearing where the state would have to prove that.
Yes, Your Honor.
As to your misdemeanor, you understand you're pleading no contest to the misdemeanor cases.
Yes, Your Honor.
And that tells me you believe the state could prove your guilt to a jury and you're not going to contest that.
No, Your Honor.
Okay. You're not going to contest it.
No, Your Honor.
Okay. And you understand by doing this, you're waiving your right to that trial by jury where the state would have to prove your guilt.
Yes, Your Honor.
All right. And as to your violations, you're going to be adjudicated guilty if not previously reinstate to your standard probation and extend the term of your probation by 12 months. Now, is that 12 months from the original termination date?
Yes, Your Honor.
Okay, so whatever your original termination date is, you'll have an additional 12 months from that. No substances without a prescription. And you're going to serve 90 days in the county jail with credit for time served as part of that probation. Substance abuse evaluation, recommended treatment, abide by any injunctions, and you'll have the additional fees and costs. As to your misdemeanor, it's an adjudication of guilt, 90 days in the county jail, credit for time served, and the court cost of $270. Are we going to pay those misdemeanor court costs inside the felony case?
Whatever's easiest.
Well, one of the reasons I'm saying that is if you don't pay those court costs, it could have an impact on you outside of your probation. Now, if I order you to pay it in your felony case and you don't pay it, then it could be a violation of your felony probation. So,
It's just $270, right?
yes, it's $270. So the issue is if you don't pay it at all, then you could end up with a collection, which could have impact on you. If you don't pay it in your felony probation, then probation is going to say you're violating your term. So either way, it could have an impact on you. So you might want to just ask Ms. Yeske for her opinion on which you think is best for you to get things squared away.
Thank you for that time. We would request to keep the court costs with the misdemeanor.
Okay, so they'll be paid independently. He'll have 90 days to get those payments made before they're reported to, well, he's in jail for 90 days. We'll give him a year to get the misdemeanor costs paid, Madam Clerk.
Thank you.
Okay?
Next, we have Adam Stevens.
Your Honor, this is Samuel Stevens before the court in 12 CF 2430. We're here today for a competency determination. In this case, Mr. Stevens just recently returned from Florida State Hospital, and there has been a forensic mental health assessment. In the record, I also have a copy if the court would like.
I've read it.
At this time, we would request the court to find Mr. Stevens competent to proceed.
State.
No objection, Your Honor. State stipulates to the report.
All right. Court finds the defendant able to proceed at this time, and we'll set it for...
Your Honor?
Yes.
We've actually come to an agreement to resolve the case as well.
Okay.
These are the following terms. It will be admit the violation of probation, an adjudication of guilt, 13 years in the Department of Corrections with credit for all time served. This includes credit for the initial time served in the case, in addition to credit from the date of the violation of probation arrest, and this includes all of his time spent at Florida State Hospital. The agreement will also include revoke and terminate the probation, pay $100 violation of probation cost, and $150 cost of defense, and we would request 2 years to pay. We would request 2 years to pay on those costs.
All right.
And Your Honor, for the record, I have reviewed the agreement with Mr. Stevens. He didn't have his glasses today, so he hasn't read it, but I reviewed the terms of the agreement with him.
All right.
And I will just need his signature. Sign here. I have the assigned agreement with the score sheet if I may approach.
Granted. All right, Mr. Stevens, if you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you put your hand down. You heard what Ms. Yeske said, and you signed the written plea form?
Yes, sir.
All right. And you understand by this plea arrangement that you're admitting the violation?
Yes.
And that tells me you agree with your officer that you violated your probation?
Yes.
And by doing that, you're waiving your right to a hearing where the state would have to prove that?
Yes.
In this case, you will be adjudicated guilty if you weren't previously, and your probation will be revoked and terminated. You'll have the fees and costs that were announced. You get 2 years to pay that. And you'll have sentenced to 13 years in the Department of Corrections, credit for all time served. That includes all the time served previously. in addition to the credit from the VOP arrest, and including all time that you've been at the Florida State Hospital. Does the state concede that the time has been served?
Yes, Your Honor.
All right. Ms. Yesky answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how she's represented you?
Yes, sir.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
This way, sir. Mr. King Walker.
Judge, this is Kane Walker before the court. He's here in violation of probation 24 CF 2809. My office has not been appointed in that violation, but we have been appointed in the underlying misdemeanor, which is 26 MM 1450.
You're appointed in this case.
Yes, Judge. And I have reached out to the state, and I didn't need to talk to Mr. Walker because I anticipated the appointment. I would enter a denial today and ask for a court date to be set without subpoenas so that we could negotiate with the state.
All right, and how far out do you wish to move it, Mr.?
Next available, Judge. I believe if we could have 7:16 at 9 a.m.
No subs?
Correct.
All right, very well.
Mr. King, at your request, I have Christopher Carpenter.
Thank you. Madam President, we're going to call two off the 2 o'clock docket, Christopher Carpenter and Jack Felt.
Now, I had on Mr. Carpenter, I had noticed that we were to have someone from remotely appear. Is that no longer necessary?
I believe it would be no longer necessary.
Okay.
Do you have any questions? Okay. Mr. Carpenter is here before the court in 16 CF 1849. This was scheduled for a contested evidentiary hearing this afternoon. We have reached the position where Mr. Carpenter is going to admit to violation 2 only. There are grounds 1 and grounds 2. Mr. Carpenter is going to admit to ground 2. There is no agreement with the state. This would be a plea to the bench, and we would request time to prepare for sentencing, as some of the people testifying at the sentencing would be remote from Ohio. May I approach with the plea agreement?
Granted. All right, raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, Your Honor.
All right, you understand that you're admitting the violation as to Section 2 only.
Yes, sir.
And that tells me you agree with your probation officer that you violated the probation as stated in Provision 2.
Yes, Your Honor.
By doing this, you understand you're waiving your right to a hearing where the state would have to prove that violation.
Yes, Your Honor.
All right? And important part of this is that there's no agreement regarding your sentence.
Yes, Your Honor.
What does that mean?
It means that it can be anything that you would want when we come back in on what the sentence would be, Your Honor.
Right. And it could be up to 30 years in state prison.
Yes, Your Honor.
Right. Now, it's not a funny situation, but I try to use a stupid example so you can understand.
Yeah, I understand, Your Honor.
You know, if I'm just in a bad mood on sentencing day, I can put you in jail for 30 years just because I'm in a bad mood. Now, it might not be the right thing, it might not be morally correct, but you know what? It'd be absolutely legal because you're leaving it up to me. Completely my choice. You understand that?
Yes, sir, Your Honor.
Now, Mr. McKinney's told me that he wants to do his job as a lawyer and have a sentencing hearing where he has an opportunity to present what he believes are the important facts I need to know to make a good decision, not based upon one that I'm grumpy about, okay?
Yes, sir, Your Honor.
All right? So you understand, still with that, it's going to be completely up to me.
Yes, sir, Your Honor.
What's the score sheet show?
Your Honor, the score sheet show 1 count, traveling to meet a minor, is a second-degree felony with maximum exposure of 15 years, minimum guidelines 25 months, 0.5.
As charged in count 4, this is actually F1.
Okay. I had it as 2.
So that would, but it would still be the 25.5 minimum?
Yes.
Okay, so it's presumed or believed that come sentencing, you're going to serve 25.5 months in the Department of Corrections.
Yes, sir, Your Honor.
So that's the minimum guideline sentence that you're looking at this
Your
point
Honor.
in time. Okay?
Yes, sir.
Does that change your willingness to enter into this open plea of the court?
No, that's what me and Mr. McKinney discussed yesterday.
Okay.
And that's actually lower than what we came
That's
up
fine.
with.
That's fine.
Back in the day, it was charged as an F1 outside, because it was 15 by 15. So,
Okay.
yeah, it's not going to change the score sheet.
No, it's not, yeah.
Thank you, Judge.
All right. The court will find the plea to be freely and voluntarily entered into. Will accept the plea. How far out do you think you need, Mr. McKinney, for sentencing?
Judge, I'll defer to the state because I know that there were some scheduling complications with the other division. I believe that 7:23.
It's fine.
Would be fine in the afternoon because I would expect testimony.
All right, 7:23 at 2 p.m. Central.
Thank you.
Yes, sir.
Okay. All right, thank you now. Good day.
Next is Jack Hill. Judge, this is Jack Hill Jr. before the court in 12 CF 312. Do you have any questions? Everything the same? Can we talk? Okay. And this was also scheduled this afternoon for a contested VIP evidentiary hearing. Mr. Hill at this time does wish to admit to the violation of probation in violation 1 only. There are 2 grounds for violation on the affidavit. There is no agreement also with the state. In this case, it would also be a plea to the bench. We would request the same date of 7/23. May I approach with the plea agreement signed by myself, my client, and state?
Granted. And what's the score sheet on this?
In this case, Your Honor, is facing a first-degree felony, 30 years maximum, a minimum presumptive, 111 months, .85.
Okay.
May I approach?
Granted. Raise your right hand for me, please, sir. You swear or affirm testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
All right, you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
You understand by this plea arrangement that you're admitting the violation as to ground one?
Yes, sir.
And that tells me, Judge, I agree, I violated my probation just the way my officer says I did in ground one.
Yes, sir.
By doing this, do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
All right. And do you understand there is no agreement regarding your sentence in this case?
Yes.
What does that mean?
There's no agreement as of right now.
Okay, well-
What they're going to sentence me to.
What does that mean to you?
They're going to negotiate. May I have a moment, Judge?
Yes. All right, what does it mean?
Means that the decision is going to be yours completely.
All right, and what's the potential outcome?
Prison.
All right, how much?
It said what would be? The maximum is 30. Yeah, maximum is 30.
Right, and the presumptive minimum is 111 months?
119.
119 months.
Yes.
Right, so it's presumed or believed you go into prison for 119 and could be up to the 30 years. All right? And, you know, it's not funny, but I try to emphasize, you know, somebody cuts me off in traffic and on the way to your sentencing hearing, and I'm just mad. I can take it out on you and put you in prison for 30 years.
I understand.
Might not be the right thing to do, but it would be absolutely legal based upon this plea agreement. I could just do that just because I'm mean,
I understand.
right? Now, Mr. McKinney's told me that he wants a sentencing hearing where he can present to me the evidence, the facts that I need to know to make a good judgment about what sentence is appropriate. But it is absolutely up to me. You understand that?
Yes, sir.
Okay. And we talked about what the minimum guidelines are and what the maximum is. Does that change your mind as to your willingness to enter into this plea?
No, sir.
All right. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfy what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into. We'll accept the plea. And we'll set it for sentencing on 7/16 at 2 o'clock.
Can we do 7:23?
I'm sorry, 7/23 at 2 o'clock.
2 o'clock. Thank you, Judge.
7/23 at 2 o'clock. Okay?
Your Honor, we have Ms. Ursula Evans Lowe, 24 CF 2698. We have reached an agreement with the state. In exchange for an admission of the violation, it will be a term and revoke with 2 years Department of Corrections with credit for all time served, and that includes the 12-1 she was previously sentenced to, court costs, cost of prosecution, and cost of defense. I just need one moment for my client to sign.
Yes, sir.
And Your Honor, this is a downward departure for the purposes of a legitimate uncoerced plea bargain.
I may approach the signed forms, Your Honor, and the score sheet.
Granted. All right, raise your right hand for me, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard Ms. Cochran said you signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that tells me you agree with your probation officer that you violated your probation the way the officer says in the affidavit report.
Yes, sir.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove the violation.
Yes, sir.
In this case, your probation will be revoked and terminated. You get 2 years in the Department of Corrections with credit for all time served. You'll have the additional $100 cost of prosecution and $150 state-provided legal assistance added to your, and plus your outstanding. And how much time to pay, Mr. Cochran?
2 years, Your Honor?
24 months to pay. Now, Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied what he's done for you?
Yes, sir.
That's all right. That's all right. The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Is there,
And, Your Honor, just for the record, that includes the 12-1 she was sentenced to previously.
for the credit, the time served,
Yes, ma'am. It's all a credit for all time served. Yes, ma'am.
the 12-1 included?
Yes, ma'am.
Yes, sir.
Mhm.
Thank you.
Thank you, Your Honor.
Go ahead. Oh, okay.
Your Honor, whenever the court's ready for the PTD, it's going to be a bond hearing. We're ready to move on it.
Say again?
Mr. McLovich, the PTD, it's going to be a bond hearing, so if the court's ready to address it, we can.
Well, we're ready if you're ready.
Your Honor, before the court, we have Mr. Stephen McLovich, case number 26 CF 1075. This was set for a pretrial detention. I believe the state's gonna, has agreed to do this a bond hearing rather than the hearing.
That's correct, Your Honor.
All right.
Your Honor, at this time, the state is not moving for pretrial detention. We would be requesting.
Well, you previously did move, right?
Yes.
So you're not moving forward on your motion?
That's correct, Your Honor.
Okay.
We would request a bond in the amounts of, on count 1, possession of a controlled substance, $2,500 cash professional. Count 2, trafficking in fentanyl, $150,000 cash professional. And then count 3, a POP, would be an ROR bond is what we would request. When we look at specifically the count 2, obviously we're requesting a higher amount. Under the factors under 903046, when we look at the facts or the circumstances of this offense, there was the fentanyl found with a digital scale. The witness that was with the defendant stated that she had observed multiple people coming and going from the hotel room that they were at, indicative of narcotics distribution. Further, there was $619 in cash found with these narcotics. And then the defendant spontaneously uttered that he was going to be facing a 7-year mandatory minimum sentence, which indicates that he knew not only of the substance, but even the potential consequences for possessing that substance. All of that goes to show that not only is this indicative of the possession of a trafficking amount of fentanyl, but also the distribution of that fentanyl, which the state thinks is important to note. When we also look at previous conduct of the defendant was previously sentenced to a Department of Corrections sentence for the crime of burglary of a dwelling, unoccupied dwelling, sale, manufacture, delivery of cannabis, possession of controlled substance, and carrying a concealed weapon. He was released from that prison sentence on November 4th of 2024, and then by June 11th of 2025 was rearrested for the crime of possession of controlled substance. The state feels that all of this taken in totality under the factors of 903046, that it shows that his past and his current actions indicate a disregard for the laws of this state. And we feel as though, given that it's not only possession of a trafficking amount of fentanyl, but that the actions and the statements of the witness and the pieces of evidence found indicate distribution of that fentanyl, that $150,000 cash professional is a reasonable bond for that charge, Your Honor.
Your Honor, if I may take some testimony from my client.
Raise your right hand, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Mr. McLovich, how long have you lived in this area?
Over 30 years.
Okay. Do you have family in this area?
Yes, I'm a mother, which is Bonnie McLovich, and I have a brother, which is Andrew McLovich.
Okay. Were you currently employed before you were arrested?
No, I was not.
Okay. Have you ever had a failure to appear?
No, sir.
Okay. If the court were to impose any conditions such as pretrial release, would you follow those conditions?
Absolutely.
If they were to include GPS and/or drug monitoring, would you follow those conditions?
Yes.
I have no further questions at this time, Your Honor. Actually, I have one more, I'm sorry. What is the most bond do you think your family could afford?
I would say maybe 10,000.
And that's total
Cash,
bond?
yeah, the cash professional.
I have no further questions for my client, Your Honor.
State has no questions for this witness, Your Honor.
Your Honor, I would ask for the $2,000 on count one and $8,000 on the trafficking. My client is entitled to a reasonable bond. $150,000 is completely out of reach for him and his family, which is he's my client, so presumed that he couldn't afford that. So we would ask for a bond that is lower. I will highlight for the court that a lot of these fentanyl street tests for the fentanyl have been coming back as positive, and then they come back from FDLE as something else. I think the court should consider that. And the police report doesn't list a weight, it just says an approximate 5 grams. We don't know if that's 4 point something or 5 point something. So it could be closer to a non-trafficking amount. And so we would ask the court to consider those things and considering the bond amount. And Your Honor, one other thing, specifically with this, last year, Mr. McLovich was charged with a trafficking charge of fentanyl, and that came back as, what's the substance called? Mannitol, which was not a controlled substance. So, to highlight how those tests are coming back, he's already had this happen to him once last year, and there's a chance it could happen again this time.
So that was the 25-1231 case?
I believe that was the case number, Your Honor.
Considering the presented, considering the defendant's criminal history, considering although the state's not proceeding forward with the pretrial detention order motion, the court's considered the factors of 903-046. The court finds that on the PO CS 2500 is an appropriate cash or professional bond. On the PO possession of paraphernalia, ROR is appropriate. However, the circumstances presented, and particularly all I've got in front of me right now, right, is what I see as far as the defendant's criminal history, what I've heard today, and the addendum of probable cause. And as my Uncle Russ used to say, ifs and buts were candy and nuts, we'd all have a Merry Christmas. So I don't know what the testing will come back. If it comes back mannitol, then I'm sure I'll face a bond reduction motion.
Yes, sir.
So $150,000 is a reasonable bond on the trafficking in fentanyl case.
Thank you, Your Honor. And on this afternoon's 2 o'clock docket, Your Honor, we had a restitution hearing scheduled for Ms. Jennifer Lample, case number 25 CF 1882. We have reached an agreement as to that restitution amount. I have a proposed order here. The state's agreed with it, if I may approach.
Granted. So that's 25-1882. The state's agreed to the form of order.
Yes, Your Honor, and just for the record, I actually spoke with various different individuals from the American Legion. They all understood and agreed to this restitution amount in lieu of having the restitution hearing, and we've reviewed the order and everything is good to go.
So order is executed.
Thank you, Your Honor.
Remove it from the docket, Madam Clerk.
Yes, Your Honor.
Judge, also on the 2 o'clock docket, I have Dejan Kimbrough and 17 CF 3377.
Yes.
I had asked for them not to transport him today because we're going to be requesting the continuance. I did meet with him yesterday. We're still waiting on Chrome to go through their application and interview process to identify whether or not we can make that argument to the court or not. I would ask for this to be reset on July 23rd.
There's no objection from the state, Your Honor.
All right, continue to 7:23 at 2 o'clock.
Thank you, Judge.
Central Time.
Yes, sir.
All right, so I'm looking at a couple of things left on our 9 o'clock docket, right? All right.
I have a plea from the 130 docket, Your Honor.
All right.
Agree with that, Your Honor?
Yes, sir.
We've already reviewed the agreement, Your Honor. I just need a signature. We have Mr. Ryan Moss, Your Honor, in front of the court today. He has two cases, 26 CF 0887 and 25 CF 1562. Your Honor, we have reached an agreement with the state in exchange for a plea of no contest. The state has agreed both cases, both cases, count one will be 3 years standard probation, substance abuse eval, and 100 hours community service, court cost of defense. On 26-2887, counts 2 and 3 will be credit time served. On 25-1562, count 1 is 3 years standard probation, basic driver improvement course, restitution reserved for 180 days, and court costs. If I may approach, I have the signed plea form and the score sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
right, you heard what Mr. Cochran said, and you signed the written plea form?
Yes.
All right, how old are you?
43.
How much school do you have?
12 years.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And is what you read in the plea form what Mr. Cochran just announced to me?
Yes.
All right. Do you understand you're pleading no contest to the announced charges?
Yes.
And that tells me you believe the state could prove your guilt to the charges and you're not going to contest it.
Yes.
You understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt to the jury.
Yes.
And in this case, you'll be adjudicated guilty and be on 3 years of probation with 100 hours community service, evaluation and treatment, plus the court costs, and those would be, Madam Clerk, court costs.
In the 25 CF 1562, it'll be 548, not including public defender assistance. And in 2026 CF 887, it'll be 615, not including public defender.
And it'd be $150 state-provided legal assistance in the 83 case, and $100 state-provided legal assistance in the 1562 case. You'll also have to attend the driver improvement school, and restitution will be reserved for 6 months. Is that what you understood? Mr. Cochran answered all your questions about the plea and how it affects you?
Yes.
You satisfied with how he's represented you?
Yes.
The court will find the plea to be freely and voluntarily entered into and accept the plea. And oh, by the way, it's credit for time served on 2 and 3.
Thank you, Your Honor.
All right, thank you.
I have one last thing, Your Honor. We don't need to bring him out. Mr. Travis McLemore, apparently he had a third case that wasn't on the docket. And that case number is 25 CF 0562.
Your Honor, this time in 25 CF 0562, we would be announcing.
McLemore?
Yes, Your Honor, there was another case that we had missed.
Okay.
The state would be announcing a dismissal of the violation of probation and a termination of supervision in 25 CF 562. This is in part to the agreement that we made on the other case because he is going to be serving 16 years in federal custody, Your Honor.
All right. So we need to amend the plea. No, you're dismissing the VOP?
Yes, that's correct, Your Honor, and then terminating supervision.
I've already provided Madam Clerk with that case number and the information.
We good, Madam Clerk?
Yes, Your Honor.
Okay. All right. Thank you very much.
Thank you, Your Honor.
So I'm showing 4 left on the wall.
I'm only showing 2 left, Your Honor. 1 defendant with 3 cases and
Okay. I'm showing Daniel Godwin.
yes, so that's one we haven't addressed yet.
I'm showing Ralph Robinson.
Yes.
And I'm showing Raul Perez.
We handled Mr. Perez, Your Honor.
Did you say Raul Perez?
Yes, we did.
Yes,
Sorry,
that was the,
I apologize. Yes, we did.
And then in Mark Robinson, there was an order allowing the public defender to withdraw and appointing RCC. However, it's now our understanding that RCC might also be withdrawing with Mr. Nopes. I'm not sure if this was addressed yet in court. Just for the court's awareness.
Mr. Notice just now basically, Judge, obviously didn't know about being appointed, he wants to know what Judge Stonewall did.
Have we got him back there?
Yes.
Yeah, see if Mr. Nopes can get on Zoom. Good afternoon, Mr. Nopes.
Good afternoon, Judge.
I believe you were appointed just today or maybe yesterday, Mr. Nopes, for Mark Allen Robinson. Is that right?
Yes, sir. We actually tried to access those text numbers today, and it's grayed out to where we can't click the name on the case number and see anything about it. So I think I'm assuming this is probably a BOP arraignment.
Yes, sir, it is. And we got 3 case numbers for Mr. Robinson. We have 23-2606, 23-2731, and 24-2395.
Okay. We're denying the BOP.
All right, you want to set it without subpoenas for the next available date, Mr. Nopes?
Yes, sir.
All right, and that'll be 7/16 at 9 o'clock. And Mr. Nopes is your new attorney. He'll be up to meet with you and chat with you about your case.
Okay.
All right?
When was the court date, Your Honor?
7/16.
7/16. Thank you.
All right. Thank you.
Yes, sir. Thank you, Judge.
Thank you, Mr. Nopes. Good day.
You as well.
Londra Lucas. Did we take care of Londra Lucas? Yep, we did. We took a plea there. All right. So that just leaves us with Mr. Daniel Godwin.
He's on restitution,
Your Honor, if I can address that, ASA Glisson had emailed me. He is in the Forest State Hospital. when I was speaking with her, I tried to look up the record myself in terms of what the status of any potential report would have been. The last report was actually October 21st of 2025.
Right, I think I placed this for hearing for a status, just to be sure it didn't get lost, and I noticed that there was an appeal that was dismissed as well. So I think we should set this again for status in no more than 6 months.
That ASA Glisson requested status in 6 months.
Okay, Madam Clerk, set this for status in 6 months, just to be sure that we, that will keep the case active.
So set it for December 17th now?
December 17th, that good?
Yes, Your Honor.
(12:17) at 9 a.m. All right. Does that cover our morning docket?
Yes, Your Honor.
Okay. And it covers our 12:30. We'll see you at 1:30.
Thank you, Judge.
All right.